As I mentioned in another video, retroactive child support refers to child support that a payer parent should have paid for their children for a previous period of time, but they did not actually pay this amount. Retroactive child support is not automatic in every separation or divorce. However, retroactive child support is not an exceptional situation either. Courts will review a number of factors to determine whether a payor parent should be paying retroactive child support to the other parent for their children. Hi, my name is Thomas Lamel. I'm an experienced family lawyer in Durham region and the GTA. Courts will closely examine the reason that a spouse who is entitled to receive child support did not apply to court for child support for their children. This parent must provide a reasonable excuse or justification why they did not seek a court order for child support at an earlier date. A reasonable excuse may exist, for example, when the recipient parent lacked the financial or emotional means to start a court application or was given inadequate legal advice. A recipient parent will also have a reasonable excuse when the recipient parent had justifiable fears that the payer parent would react in a vindictive manner to the detriment of the family. However, a recipient parent will generally lack a reasonable excuse when they knew that they were entitled to a higher child support amount, but they simply decided not to start court proceedings to get this higher amount of child support. A payer parent who tells the recipient parent about their income increases in a timely manner, it does not pressure or intimidate the recipient parent, will go a long way towards ensuring that any delay on part of the payer parent on pursuing child support or increased child support is viewed as an unreasonable delay. But you must remember that the recipient parent's unreasonable delay is merely one factor a court considers in deciding whether it should exercise its discretion in ordering retroactive child support. Courts will also take into account a payer parent's blameworthy conduct in determining whether retroactive child support is appropriate in a case. Courts are taking a broad or expansive view of what constitutes blameworthy conduct. For example, a payer parent cannot hide their income increases from the recipient parent in the hopes of avoiding larger child support payments. A payer parent cannot intimidate a recipient parent in order to stop the recipient parent from starting a court application for child support. A payer parent cannot mislead a recipient parent into believing that the payer parent is meeting their child support obligation when the payer parent knows that they are not. A payer parent who knowingly avoids or lowers their child support payments to the recipient parent will not be allowed to profit from this conduct. It is also important to know that a payer parent who does not increase their child support payments automatically is not necessarily engaging in blameworthy behavior. For example, a good indicator of whether or not the payer parent is engaging in blameworthy conduct is whether or not the payer parent has a reasonably held belief that they are meeting their child support obligations. A court could compare how much the payer parent should have been paying and how much they actually paid. Generally, the closer the two amounts, the more reasonable the payer parent's belief that they met their child support obligations. A court will also consider any previous court order or agreement that the payer parent was following. Since the court order, and usually the separation agreement, are presumed valid, a payer parent should be presumed to be acting reasonably by following the court order or separation agreement. However, this presumption will be eliminated when a change in circumstances is shown to be significant so that the payor parent is no longer reasonable in relying on the court order or separation agreement and not disclosing their revised or changed ability to pay. Another factor to consider is the present circumstances of the child in deciding whether retroactive child support is justified in any particular case. A child, for example, who is currently enjoying a relatively high standard of living may benefit less from retroactive child support than a child who is currently in need. The child's current standard of living is an important point for courts to examine, since it is a key principle of child support that a child's standard of living after their parents have separated should be as close as possible to the standard of living that they had when their parents were together. Courts will also look at whether retroactive child support would cause hardship to the payer parent. For example, a payer parent may have a new family, along with new family obligations to meet. It would be difficult to justify retroactive child support when it would cause undue hardship to the payer parent's other children. Make sure you spend some time with your family lawyer discussing this important issue in your separation or divorce. If you have any questions about your separation, divorce, or family law case, and you'd like our help, there's a few ways to contact our office. You can leave a message on my Facebook Law Office page, that's O'Malley Family Law. Visit my website at www.canadiandivorcelegaladvice.com or call me directly at 905-434-8837. We'd be happy to speak to you. Oh, by the way, did you know you can protect your family law rights and get essential information on settling your family law issues with your former spouse with the daily, indispensable family law advice and tips at my free Facebook group? Go to Facebook and search Durham Region Separation and Divorce Legal Support Group in the top search bar. You'll find the group and join. Thanks for watching this video, and have a fantastic week. Take care, everyone.